Okay. So today we have Chris here from Convex Legal, and I'm going to go to Chris. We are talking about the SEC and disgorgement, and I had a lot of questions to ask him, so I figured why not do a podcast with Chris? So I'm going to bring him on. Okay, so... Okay, there we go.
All right.
I think you're there. You there?
Sounds good.
Okay, yay. So, like we talked about before, for more than 40 years, the SEC has used disgorgement as a key mechanism to gain compliance through enforcement actions. And with a writ of certiorari tomorrow, we're going to be hearing about Lay versus, and I don't know if I said that right, versus the SEC. So this could soon come to an end. So we just wanted to know more about this. And thank you so much. So Chris and I are doing this podcast. We're really excited. I have so many questions about regulation and such. And so I'm excited to dig into all these regulatory matters. So with that...
Well, I'd like to introduce you as well, if that's all right here. So we have Jenny here with Lula & Co. And one of the things that really draws our attention to your company is the focus on cybersecurity and blockchain. But around that, you take that whole angle and you look at the education side, which is really important, especially as more and more people want to get involved in blockchain and as more and more people realize what cybersecurity involves or entails, especially when you include personally identifiable information and when you throw in education, healthcare, things like that, and what the information that they have, you've really been able to take all three of those, the education of blockchain and cybersecurity, and show how they play out together. So we at Convex really like talking to you and learning.
You are awesome, and I love it. It's so much fun because they're complicated concepts, but if you can make them kind of simple, I don't know. They're not that, I would say they're so abstract, right? And if we always talk about education and the people in the ecosystem and how this would change things. And so a lot of it, I think, comes down to education. So thank you. You're so sweet. And I love Convex because I direct many people to all of my legal friends because we just want compliance, right? For our space to grow.
And then we scare them away with doom and gloom. So there you go.
Well, it's more about the hypotheticals, right?
Oh, yes. Oh, yeah. They're great.
Yes, the hypotheticals. So one of the cases when Chris asked if we should do this, we were like, yes. And then I found out that this case, and we've heard about Block 1 has had a disgorgement, right? They had I forget, it was 26 maybe million.
Yes, yeah.
Right? And you hear these terms, and a lot of people in our industry, I don't know if they really know what those mean. So can you kind of explain what disgorgement means and why this case is before the Supreme Court and why it matters?
Yeah, so there are different ways of I'll say recovering, but it's not necessarily recovering money for the investors. There are different ways of a company having to pay out in the end of a court case. So it could be civil penalties, it could be disgorgement, it could be, punitive damages. So the idea is just to kind of bring things back to status quo. And disgorgement is a big one for the SEC. I believe that it's about, they said last year was 64% of the money that came in was through disgorgement. So this Lay case is very interesting in that they are trying to remove disgorgements as an option for the SEC within federal court.
Which is, it's so crazy. 65%, that's a lot. Because we read this same report and it was, wow, that's a big chunk of money.
Oh yeah. It wouldn't get rid of disgorgement as an option as a whole for the SEC, but at least in federal court. So all of a sudden, it would limit their game plans for how to approach different companies.
Okay. How do you think that would, so can you explain just a little bit about it's kind of complicated, right? The way that a case goes forward, the difference between like administrative law, right, or administrative law judge, or the SEC, or civil court, or federal court, and the process there, because I think that a lot of those terms, I don't know, a lot of them can be kind of confusing.
Yeah, so for this situation that we're talking about with disgorgements, we're looking at federal court and then administrative through the SEC. So you can, the way to kind of oversimplify it is just that there's federal court, which is what people tend to think about when they think of court, or administrative would just be, think of in-house. So all of a sudden it's the SEC, it's people that are paid by the SEC to make the decision. So it's another court proceeding. It's just the rules are slightly different, and it's not a federal judge that is making that decision necessarily. It might be an ex-federal judge, but not a current one.
Okay, that's really helpful, because I wasn't sure, even as I was reading through some of the enforcement actions, you know, how does a case though go then? Like, okay, so let's say that it goes through administrative action and there's an enforcement action. Does it always go through to the federal court then, or is that an option, or do they recommend that, and is that part of the order?
Oh boy, recommend through the options. That's let's see. So the attorneys will help their client, or the attorneys on the SEC side will make the decision of which approach is more beneficial for their case. So they want to take the stronger stance for themselves. The idea with the administrative side is that it's going to be faster in a sense, and but all of these you're allowed to appeal. So it's not necessarily the first case is not necessarily the final decision, and that's what we're seeing here with the Liu case, is that they're appealing the decision.
Oh, okay.
All the way up to the Supreme Court.
So if an enforcement action is in administrative court, right? Sorry, I think I have to plug in my computer a little bit there. Oh, I gotta love the power situation. But anyway, yeah, it's charging now. So so it's basically like an appellate court, right? Am I understanding that?
Think of
no.
Yeah, that's fine. I mean,
rough terms, obviously not actual terms. Trying to conceptualize it.
Where you're taking the case, and who is making the decision, and the rules that apply to how the case proceeds. So timelines, deadlines, things like that.
Deadlines. Those are very important to courts.
You'd be surprised how many people miss deadlines, and then there's trouble.
Oh, wow. Okay, so that's always good to know, especially because like a lot of the people that we chat with and things, if they're in emerging technology or blockchain and crypto, they may not know that. So that's important. So then it was talking about like, so the article that I kind of sent you that gave us like kind of a direction of where to go, right?
Yeah.
What do you think about what they're going to decide, or what do you think that this bearing may have on the either blockchain and crypto companies or any company?
So we're going to have to link. We definitely will link the article, because we don't want to plagiarize here. But they make a good point that that this is only right now. It's only for federal court, and the argument is that so there's the Kokesh case that states where the court decided that yes, disgorgement is a penalty, and the reason that was important in that case was because they're talking about statutes of limitation, which would be 5 years. In this case, they're arguing, in the Liu case, they're arguing that there are only 3 types of relief that are allowed in federal court for the SEC currently, which would be injunctive relief, equity relief, and then civil money penalties. So they're claiming that disgorgement is not an option. That it now in federal court, as the article points out, then they do a great job of showing that that does not mean that disgorgement's barred from administrative cases, and it also points out that the SEC could always go back to Congress and ask for permission to have disgorgement. So it just might might create some friction for the SEC that they have to get around or decide. Again, as we mentioned at the beginning, either it limits where they can do disgorgements, or it kind of postpones them being able to request that until they get permission from the Congress. This is all assuming that the final decision is that yes, it's a penalty that is not allowed in federal court. So we'll see how that turns out. In my opinion, well, my opinion doesn't count for much, but I'd keep disgorgements around. But we'll see. One way or another, the SEC will still be able to. It's just, do they have broad choices on where to request disgorgements, or are they limited?
That's really interesting because, especially because we're talking about how, we're hoping that there's going to be some sort of crypto legislation coming forward or token legislation, and I wonder if they're going to treat legacy markets and crypto markets the same, or if there's going to be specific, because you did mention them going to Congress, right, that potentially they could ask for more authority, and maybe, I don't know, just curious if they would ever ask for more authority in the emerging technology space, or if that would be be unfair.
So, what we're hearing through the grapevine, I'll say, is that the first couple waves of the ICO cases were they're doing rescission, so that's different, right? That's really what they've been focused on. So on that side, money going back to investors. So I don't know if they'd have to request more power for actual penalties or repercussions for improper capital raises, or if you're creating an exchange that has securities and you're not a registered exchange, or if you're transacting in securities, even in a peer-to-peer sense, without permission. Let's say it's a Reg D raise and you're a non-accredited investor selling to another non-accredited investor. Somehow you got hold of these tokens. Like those, they're not going to have to, the SEC will not have to ask for more permission to get those, to take those cases, but at least from the penalty or the fine or the punitive point of view, they might want more permission on, or they'll most likely give more guidance or clarity on what they're looking at, what they're looking for to go after. But if they did want to use disgorgements, from what we see with the Kokesh case, they have 5 years. So as we were talking about before this video, if that first wave was about 3 years ago, then you have about 2 more years there. So that the real jump, that was in 2013, right? No, sorry, 2017. Yeah. 2017, when they had all the big wave of ICO, 2016, 2017. It does not remove their liability completely, but it might be one less option for the SEC in another 2 years.
Wow.
So they'll either have to get busy or choose other options.
Which is kind of like, how long does, obviously every case is different. Fact pattern and circumstances are all different. How long does it actually take generally for a case from the time of complaint and then the investigation and such to actually get even to one of the processes?
Oh, that's a good question. This is where I defer to the securities litigators that we hang out with or talk to, and we see this when we respond to requests from the SEC as well, and not just the SEC but regulators in general. Is you can send your response back, you can answer their questions, send all the data they need, and you'll sit for up to a year just not hearing anything. And it's not bad. It's not an issue with the regulators. It's just that they have a heavy caseload, and maybe yours isn't the most attractive case to look at, or maybe there isn't anything there and they want to take a closer look. They don't see anything yet. Not to say that they're trying to find something, but they want to make sure, double checking. So you can hang out for a good year without hearing anything, and then get a follow-up letter asking for more information, or worse.
Wow, it's got to be stressful because, like, if you don't know what to do in the meantime, or how to proceed in the meantime, that can be definitely be a pause on your operation.
Oh, sure. It's one of the questions we get from our clients. Sometimes they'll ask, okay, can we keep going? And that's case by case here. And then other ones, you have to send these boring emails to say, hey, it's been 3 months, still haven't heard anything, let's just hang out. So it can be frustrating for businesses that are trying to run.
That sounds like, well, especially in crypto, blockchain, or other emerging technologies, because time is of the essence. You don't, so especially if other people may have the same idea, or things move fast in our market.
Oh yes. No, and you can choose to take a conservative approach and kind of apply the laws and the cases that we have now, and take your best educated guess on how to keep moving forward. Or you can, ignore your lawyer, and just wing it, right? Just go ahead and do whatever you want to do and just hope time runs out. I would not recommend that in any way, shape, or form.
No, definitely not. Definitely
not because I'm biased for lawyers in any way.
Was there anything in Kokish that actually stood out as far as, a certain fact that really was, that kind of led to more of this, like, I think it was called, like, opening the door or into the reasoning of the case itself? Do you know what question?
On the penalty side?
Mm-hmm. In the Kokish, like the way that, because it seems like they're using the Kokish case very much like kind of like a guideline, right?
Yeah, absolutely. I mean, they define a penalty, what a penalty is in there, but they're actually just pulling from a previous case, and then how they apply. They set up principles for applying a disgorgement, and so why it constitutes a penalty, and then just they really break down the difference between a penalty and a remedial sanction. So it's I would just be rereading the case here. I think that's one that if you're really excited about finding out what punitive damages are versus penalties versus civil money penalties versus injunctive relief, you can get a quick law class just by reading that case. They do a great job of spelling it out for everyone.
Yeah. Well, and okay, so then you said, wait, you were saying something about sanction. What was that? Now I just totally lost my train of thought. Remedial sanction. What is that something that, are those all different, or?
Remedial sanction. So sorry. So you mean as opposed to like injunctive relief versus money penalties, and it's just a matter of. Well, yes, there are a lot of differences. I guess I shouldn't say just.
No, that's okay. These are generalizations. Obviously, nothing more just to educate people.
Sure. Well, some requests force or direct a company to do something or not to do something. Then you have penalties that go back to, say, the investors. Those aren't necessarily penalties, just returning of the investment. You have money that will go to the SEC, and then when they're talking about disgorgement, they're talking about a penalty that the court takes, and they decide what to do with the funds at that point. So it's not determined where that money is going to go necessarily.
Oh, okay. Oh, that makes a lot of sense. You're right, because like reading that case, I've read the case, read the article, kept finding more sources, and we'll link them all below, because every one of my articles has 30 sources, but link them all below. But it's hard to digest all of that because there are a lot of nuances with vocabulary, I think, that can throw you off, at least me.
Well, no, you broke it down nicely. For yourself, how do you think it applies for the blockchain space then? Is it going to is it going to excite people that they might try to take more risk, or do you think that it just kind of it helps them define where they want their cases to end up if they have one?
So I think, yeah, that's exactly what I think. Is I think that it's going, and this is just obviously my own opinion, right? Simple. I'm not a lawyer. I'm law student, but I think that just understanding the way that some of our companies have either the way that they like to look at the market sometimes, I think it might actually encourage a little more innovation and perhaps a little bit more risk. I wouldn't say risky behavior, but maybe that they would be more inclined to, see this as an opening. And so that's kind of why I want to talk about it, because I don't know if that's actually the accurate interpretation of what's going to go on, and or even if I understood the article right.
Well, depending on who's reading it and how they want to interpret it, it sounds like some people believe that blockchain's in this gray area. So others believe that it's really not that original and that the securities laws apply just fine. But not everyone's there. And if you have this gray area that's not well defined, then you have room to the right and the left. So a little more conservative, a little more risk taking, not necessarily. We don't mean that in the sense of, are you going to get caught for doing something bad, but so much as let's push the envelope a little bit here and then get some more clarity from our regulators, right? Exactly. I think that's where you're going with this. So it'd be interesting if this case helped people feel like they feel comfortable pushing the envelope a little bit more, getting a little more clarity from the regulators for applying traditional securities laws to a technology that was not even fathomable at that time. So.
Right. Well, and on top of that, I wonder if this is going to be a part of that reasoning, because they can kind of see that, and then you couple that in with, we were talking about the resources, we're talking about the timeline, how long cases take. I mean, that's a lot of resources to investigate, right? So this is a significant portion. And that was in the SEC enforcement report that was out in October of 2019, which we'll link below. And it was saying that, went down all of the cases, and it's really nice. Look, the enforcement thing is great because it's got all of the links. You can see you can also, you can subscribe to them and get email notifications every time they come up too. But this is like all in one, right? And you can really dig in, and for researchers, I think it's great. So I was really shocked at the amount of the budget or their the monies that they have taken in, how much that was.
And they don't get to keep that, by the way. They don't get to keep that. But yeah, that is a big, well, it's more than half of what they bring. So it would be, now that's 64%, by the way, or 65%, or that didn't break down between federal court and administrative. So it'd be interesting to see, because maybe federal court only brings 2% of that 64, in which case we're really hyping this up for no reason. But that's not the case. So it'll be interesting there. I guess tomorrow we will hear the decision, right?
Yeah.
And I guess, what's your take, or how do you think it will play out in the end?
So I think that they kind of, personal opinion obviously, but I think they kind of like laid that groundwork with Kokish, and that they're going to be, I think we're going to see less regulation, a trend of when things go forward, okay, whether it's Supreme Court or wherever they are in this process, right? I think we're going to see an overall trend of less regulation. Now, I'm not saying that in blockchain and crypto specifically at all, digital assets, emerging technology. I'm saying like overall of, securities, and because that's kind of where it seems like a lot of the articles are pointing to. So I think that, they're going to go use that as, obviously precedent and just move on that front. But I don't know exactly what that would look like, or if there's a middle ground for that.
Well, it'll be exciting. We can match that up with people can protect themselves if the sandbox kicks off, right?
Yeah, exactly. So awesome. And so I think we've talked a lot about this, right?
Yeah, we hit that.
Notes. Sweet. All right.
Thank you.
Yeah,
this has been a lot of fun.
So, and then I told you like next week, or because we want to do one of these a week. We're a little behind. Sorry, but it's coming along. So next time, and the podcast is called, and we're making it a podcast too, right? It's called As the Law Unfolds. Ever so dramatic. Super excited about that. But so the next time, like, we are thinking of talking about maybe CCPA.
Oh, really? Okay, I like it.
Mm-hmm. Or we could also talk about. There was another one that I sent you to, which remember what that link was? I could try to remember off the top of my head. I can't remember.
Well, maybe we can put a poll up, and someone can vote. We'll get one person to vote, and they'll get their choice.
Yes, brilliant. So there you go. That's perfect.
Well, thank you very much.
All right. Well, thank you so much.
Everyone, remember to check out Lula & Co. because they're great for the consulting side, education side, and just learning about blockchain, cybersecurity, and the people to know in that space.
Oh, well, thank you. And also, we're looking to interview people. So it's not just us just chit-chatting, right? And so we would love if you guys want to be on, anyone in the, either digital asset space or regular technology, regular legacy markets and everything, because we want to know more and to get more information out there.
Yes, absolutely. Thank you.
All right. Well, thank you so much. Have a great night, and we're going to sign off.
Bye.
Okay.